warm welcome from the LedX family. Continuing with the patent law series that we have been learning about, in this very present video, we'll be looking at the brief aspect regarding what we have discussed earlier in a very brief manner, because it will set up a base for our topic for the day, that is filing of patents. So we'll be discussing this into two segments of video. Into this segments, what we'll be dealing is as to what is the reason for patent filing, as to is it mandatory to get an invention patented, and what are concurrent patents, is there a concept of concurrent patents. Moreover, after that we'll be seeing as to the flow chart of patent filing. So we'll be seeing the flowchart of patent filing, so which will include various aspects such as there will be an application stage. After application stage, then there will be a publication stage. After publication, there will be examination. However, why examination should be there, even we'll be discussing that. After examination, there is opposition, and after opposition, there is grant of patent filings. So we'll be looking at this aspect. We'll be covering different aspects as to what are the formalities, what are the different various forms that we have to fill, what are the other requirements while filing of patent we have to keep in mind. We'll be discussing in this. But as for this very particular segmented video, or the first part of filing of patents, what we'll be looking as two very crucial aspects. That is, firstly, we'll be looking at the application stage, and secondly, we'll be looking at the publication stage. So for this video, we'll be looking for these two stages. So let us start with our very first segment of this video. So as we have previously discussed as to what do you mean by patents, but just as a repetitive part to kind of make everyone remember what is patents. Patents is nothing but an exclusive monopoly right that is given by the state to an inventor for his invention for a limited span of time. And that limited span of time in India is 20 years. So we see that it is an exclusive right given for an invention to the inventor for a limited period of time. So now when we have known as to the definition of patent, we have to understand what are the integral terms that needs to be defined for an invention, because only an invention can further qualify as a patent. So for invention, as we have already discussed in our first video, three things are very important: that the invention should be new, it should have an inventive step, and thirdly, there should be some industrial utility to it. So new is that it should not be known to the public priorly before filing of the application. So this is what we are today. We will be going as to look at the stage of application. After that, it should have an inventive step. Inventive step as in it should be not obvious to any person who is skilled into that particular field or art. And thirdly, it should have some industrial utility. Suppose, for example, a patent, if it's being created, or an invention, if it's being created, if it has no application into the industry, then such invention can never be classified as a patent. So these are the three very brief characteristics for an invention to qualify as a patent. So these three things are very important for grant of patent. Now, when we have seen this as to what is the meaning and what is a patent, we need to understand that is invention compulsory to be patented? No, that is not the case. If a particular inventor has created an invention, it is no mandate that he has to definitely get a patent for working of his invention. He can continue with his invention if he wants to keep it a secret and if he wants to exploit it. But to keep in mind, we have to understand that he has to bear all the risks that patent kinds of removes. For example, if I am creating an invention, there might be a possibility that anyone in the market can reverse engineer my invention and kind of come in the market as a competitor to me and cause commercial losses to me. Also, there might be a situation that if any of the close aid of me who knows about my invention, who knows about the process of my invention, kind of discloses that particular thing to some other person, and such other person creates the same invention and comes in the market and causes commercial losses to me. So we understand here, when all things are there, he has no remedy, because he has no exclusive right to exclude such others, and if such exclusion is not there, he cannot bring any infringement proceedings for the same. So we see that there is no mandate as to put an invention, give an invention the protection of patent, but it is always advisable to do so, to give the protection, to give an invention the protection of a patent, because it reduces all this risk and it grants certain number of rights to the inventor, which will kind of encourage him to build upon more and more new inventions, and moreover will reward his creativity and his human skill and labor that is involved in creation of such invention in the, and eventually got in the form of patents. So this is why we see that an invention should be patented. Now, what should be the reason for filing of a patent application? So as we see that it is a very first step for which it is a very first step from which the application the patent process started. So application is a very first stage. Without filing an application in an appropriate patent office, it is impossible that you will be granted a patent, because an application includes a lot of things which we'll be discussing in just few minutes. Before that, we need to understand that this application is to be filed in patent offices. Now we have to understand, as in the last segment or in the last video we have discussed, is certain authorities that regulate intellectual property in India. So for patent law, there are two authorities that regulate patent law in India. One is the Controller of Patent Designs and Trademarks, which is there, and secondly there is a patent office. So we have to understand that patent office is in Kolkata, the head office is in Kolkata, and it has some branch offices. So the branch offices are in Bombay, Calcutta, Bombay, Chennai, and one more is New Delhi. So we see that even the office patent of patent information system is at Nagpur. So we see that why this four jurisdictions are being created, that is Bombay, Calcutta, Chennai and New Delhi. This is because you have to file your patent application in the proper jurisdiction. If suppose, for example, if I am residing, or if my jurisdiction comes into Mumbai for filing of my application for the patent, I cannot go in Chennai and file my application. I have to file it in Mumbai itself. How this jurisdiction has been determined, we'll be looking into that aspect. But first of all, priorly we need to understand that a patent is to be filed in a patent office, and this patent office has 4 branches, with its head branch at Kolkata and the 3 other branches being Bombay, Chennai and New Delhi. So now when we know that as to why should we file patent and where the patent should be filed, we need to understand, is there a concept of concurrent patents. Now what do you mean by concurrent patents? So concurrent patents is that, can 2 persons file for the same invention separately? No, that cannot be the case, because the patent law follows with a principle that only one person can be granted one single patent. It cannot be, a single patent cannot be granted to two different persons when they are applying differently. However, they can apply jointly if they want to. They will be considered as co-owners or joint owners. But there is no situation wherein 2 different people can file for a patent separately. There is no provision for concurrent patents into the patents law in India. So we have to understand these things.